Well, good afternoon, everyone, and thank you all for giving up your lunch hour, if such a thing actually exists in COVID times, and for joining Tim and I today. 2020 was a strange and different year in many ways, and whilst we stayed in our homes for much of it, and words like lockdown, Joe Wicks, Peloton, and tears became commonplace, the world did keep on turning, and the wheels of financial regulation kept spinning. Now, today, Tim and I are going to give you a bit of a whistle-stop tour of what happened in the world of financial regulation, the world of the FCA in 2020. And we've decided to divide the talk into two sections, each reflecting two characteristics that we think were prominent in 2020 in FCA enforcement. Firstly, FSA/FCA conservatism, and secondly, the more aggressive FCA approach to enforcement that seems to have become and taken over the approach. And we will look at each of these examples in turn. First of all, the FSA/FCA conservatism was exemplified in the following events that all occurred last year. Firstly, crypto asset companies and exchanges falling under the FCA's anti-money laundering supervisory jurisdiction for the first time, the Commerzbank final notice and the proceedings in connection to that, the independent report into the FCA's handling of the Connaught income fund, and the Gloucester review of the FCA's handling of the London Capital Finance, the collapse of that. Now that's what I'm going to be dealing with. And in contrast to that, Tim will be looking at the more aggressive enforcement that seems to have become a change in approach, largely in 2020, exemplified in the following events: the prosecution of Vishynyak, the approach to MLR 2017, the Money Laundering Regulations 2017 investigations, joint investigations and prosecutions for solely non-FSMA offences, for example, the case of Faithful that we will look at, and issues of guidance to those in the cannabis sector, again, which all occurred last year. And this will be the section that Tim will take you through. Now, the conservatism, to a large extent, has been a legacy of the old agency, and the more aggressive stance, the approach of the new. Now, just before we start with the webinar proper, with regards to questions, the approach we'd like to take, and one that has worked before, is if we can save the questions to the end. And it may be that your questions are answered as we progress through the hour. But any that remain at the end, then Tim and I will, of course, endeavour to answer any or all of the questions. If we can't answer them or we run out of time, then we're more than happy to take any questions offline as well. So without further ado, let's look together at the FSA/FCA conservatism. So first of all, cryptocurrencies. Now, we could probably spend the whole hour and more looking at the world of cryptocurrencies, the concept of Bitcoins and Bitcoin mining, and indeed Bitcoin billionaires is something that we are becoming more aware of in our everyday life, in our 3D offline worlds. Whilst we are more aware in everyday life of things such as cryptocurrencies, they only exist electronically and use a peer-to-peer system supported by what's known as blockchain technology for their onward transfer. And so therefore, almost by definition, the world of cryptocurrencies was, until recently, largely unregulated. Now, 2020 saw two key developments in the hitherto largely unregulated world. Firstly, in January 2020, in fact, the 10th of January, under the Money Laundering, Terrorist Financing and Transfer of Funds Information on the Payer Regulations 2017, to give it its full and catchy title, or to its friends, MLR 2017, The FCA became the anti-money laundering and counter-terrorist financing supervisor for the crypto asset exchange providers and custodian wallet providers. Essentially, it became the regulator of cryptocurrencies in the United Kingdom. And what did it do with that? Well, in October 2020, so some 10 months later, the FCA banned the sale of derivatives and exchange traded notes that reference certain types of crypto assets to retail consumers. And that ban came into effect on the 6th of January, so a couple of weeks ago, in fact. Now, the introduction of such regulation was perhaps not surprising. By last year, the cryptocurrencies had existed for almost a decade, and they'd left the sort of realms of science fiction and had become more than just a passing fad, which people initially believed that they may be. And in fact, competition between the currencies started. And the best example being the emergence of Ethereum, which you can see the logo on the screen, and also which mounted a challenge effectively to Bitcoin, which hitherto had been the biggest of the cryptocurrencies. And that happened in 2015. However, that was going on, but there was no effective UK law enforcement, anti-money laundering supervision or cybersecurity. It was happening, but as I've said, largely unregulated at a time when it was really beginning to take off. Now, the Terrasco case, which happened in 2018, was where the Crown, in a prosecution, successfully applied to restrain Bitcoin and convert it into pound sterling to satisfy a confiscation order. And that was a clear mark that this intangible, almost science fiction-based currency was now very much accepted as part of the UK's financial landscape. However, as I said, still unregulated. Now, despite the clean bill of health that the FATF, the Financial Action Task Force, gave to the UK law enforcement's approach to the anti-money laundering and the cyber control in 2018, they did highlight, in their words, the existence of what was described as a wild west in terms of cryptocurrency in the cryptocurrency sector, and made various recommendations at that stage that the money laundering regulations should be applied and that regulation should begin to commence. So 3 questions arise so far. Why did the FCA bring in the ban that they did, that took effect earlier this month? Why did it take so long? And what can we expect to see as a result of this new regulation? Well, in answer to question 1, who better to ask why they brought in the ban than the FCA themselves? And they had this to say. They said that the FCA considers these products to be ill-suited for retail consumers due to the harm they pose. These products cannot be reliably valued by retail consumers because of, and they listed a number of things, in the inherent nature of the underlying assets, which means they have no reliable basis for valuation, the abstract element of them, if you like, the prevalence of market abuse and financial crime in the secondary market, for example, cyber theft, the extremely volatility in crypto asset price movements, and we'll look at that in a moment, and the inadequate understanding of crypto assets by retail consumers, and finally, the lack of legitimate investment need for retail consumers to invest in these products. These features, they said, mean retail consumers might suffer harm from sudden and unexpected loss if they invest in these products. So it was very much protecting the retail consumer, and with good reason. Now, they said back at the time of bringing in this ban that they estimated that the retail consumers would save around £53 million from the ban of these products. And in fact, over the weekend, so this week alone, the FCA issued a crypto warning as in fact the Bitcoin crashed by 21% this weekend. So if any of you were crypto billionaires at the beginning of the weekend, my commiserations, your slush fund may be considerably smaller today than it was, say, last Thursday. Dropped by 21%, as I say, this weekend, having rocketed through the latter half of 2020. So question 2, why did it take them so long? Well, in short, the attitude by the FSA and FCA shown during the Connaught and LCF investigations, which we'll look at shortly. In other words, an inherent conservative view of its own remit, characterised, you may think, by its unwillingness to look at matters holistically. A conservative view and perhaps a reluctance to expand its remit into such areas. Now, it may be that any member of the public coming into contact with crypto assets would probably be rather dumbstruck to learn that it was only at the end of last year and really the first action at the beginning of this that the FCA's remit began into peddling them. And up until this point, as was said by others, it was effectively a bit of a Wild West going on the platforms. So question 3, what can we expect to see as a result of this new regulation? What is the likely effect of these regulations on us, the lawyers and the investigations and those dealing in the financial sector? Does the fact that the remit of MLR 27 has been extended to cryptocurrencies mean that we can expect a raft of FCA investigations and enforcement and subsequent prosecutions of individuals and indeed perhaps the platforms themselves? Well, that's obviously a hard question to answer, and none of us have got a crystal ball, unfortunately. But the message from the top of the FCA back in 2019 was that the MLR 2017 investigations were on the rise. And Mark Stewart in April 2019, who was the Executive Director of Enforcement, said this: I think it's time we give effect to the full intention of the money laundering regulations, which provides for criminal prosecutions in making poor AML systems and controls potentially a criminal offence. The MLRs are signalling that in circumstances, MLL failures let down the whole community. And there is certainly no reason from what Tim and I have seen to believe that cryptocurrencies are going to be excluded from this renewed focus on compliance. So it really is a watch this space with regards to what they will do. So 2020 saw the regulatory foundations being put in place with regards to cryptocurrencies. And now we have to wait to see what will be built on these. So the next topic I'd like to look at is the Commerce final notice. Now, in June 2020, the FCA fined the Commerzbank, the London branch, £37,805,400 for failing to put adequate AML systems and controls into place between October 2012 and September 2017, 5 years. In fact, Commerzbank agreed to resolve the matter at an early stage of the investigation and therefore got a 30% discount. So what was an eye-watering fine of over 37 million could have been 54 million. Now, it's noteworthy because this is the second largest fine ever imposed by the regulator for breaches of AML provisions. And whilst this fine is illustrative of the FCA's tougher stance on compliance measures, despite the size of the fine, the FCA has been criticised, in fact, in its approach to this bank. Its very conservative approach that it took. Now, the breach, as I said, went on for 5 years and was also against the background that the bank was also being criticised by its US regulators at the time. So lengthy, 5 years, being attacked in the US as well. And it has been said that the FCA should have undertaken the remedial actions more promptly and efficiently. It should have acted more quickly, agreed. I think everybody agrees that, but should it have acted differently? In other words, should there have been a criminal prosecution, should they have moved away from the more conservative approach of old. Now, notably, the enforcement was not under MLR 2017, and I've no doubt that plenty of the attenders may have views about whether, on paper at least, how easy it can be, and it's easier to breach MLR 2017. Now, had this conduct occurred now, it would have automatically opened a dual track investigation, with investigators being appointed to investigate both the regulatory breaches and the criminal offence. So had it occurred now, it would be treated as a criminal investigation. Arguably, because, as I say, the sustained and blatant nature of the conduct, it would have been a prime candidate for criminal prosecution. And it seems clear from Mark Stewart's speeches, who I quoted from earlier, and the number of investigations opened in the last 3 years, that had the conduct, having been investigated, fallen within the ambit of MLL 2017, it's likely that a criminal prosecution would have resulted. So there we see an example of the conservative versus the aggressive approach, and that's something that Tim will look at in more detail in the second half of the webinar. Now, the next thing to look at is the Connaught Income Fund. Now, the Connaught Income Fund and the history of demonstrates the arguable mishandling by the FCA and its predecessor, the FSA, of the investigation into the collapse of the Connaught Income Fund. Now, for those of you who are not familiar with that, in summary, the Connaught was a £100 million unregulated collective investment scheme, which was managed by Capital Financial Management and later a company called Bluegate, that provided the capital to a bridging loan specialist, Chiwita. The terms, 8% return for investors during the 2008 to 2009 financial crisis, were attractive, to put it mildly. Now, a whistleblower who was the CEO of Chiwita, George Patelis, approached the then FCA with his suspicions that there was a shortfall in the fund. And despite that, the FSA took no action. Now, the reason for having it as a topic for today is because of the criticism that Raj Parker, the independent reviewer, articulated in a very precise way in his report that he published last month, so just at the tail end of 2020. And it very much demonstrates the conservatism of the approach that was being taken back then. A few highlighted extracts which are up on the slide. The regulator's approach was impacted by its perception of the limits to its own jurisdiction. This was in part due to the continuing internal uncertainty as to the regulatory perimeter, and these factors affected the regulator's appetite to investigate and address the misconduct issues which had been brought to its attention in respect of CAM and Chiwita. Now, if ever someone from the outside the FCA understood the internal struggles within the mindset of the FCA, Mr. Parker absolutely nailed it. The FCA is a creature of statute. It derives its power from the FSMA as amended. And the sentences I would highlight are those that I've just read. If ever there was an event that crystallized the problems that the FCA creates for itself with such a rigid interpretation of its remit, it was Connaught. And as I said, may have been one of the reasons why it took them so long to step up with regards to cryptocurrencies and regulating that. By inclination, it wanted to stick to honouring its core principles, maintaining the integrity and fairness of the market, its core principles, and where the activity being conducted was 95% unregulated, that had to mean, in its mind, by its definition, a completely hands-off approach. But that didn't allow for the 5% regulated activity that was occurring, and left a situation where investors were confused and not sure whether they were investing into a fund that was or wasn't regulated by the FSA, FCA, and had therefore the protection of it or not. Now, it was a sad state of affairs, and Raj Parker's review sets it out. But if there was one observation that could perhaps cast the FSA, FCA's conduct in a more favourable light, it's the fact that successive governments have failed to properly keep FSMA up to date and relevant. And what we're left with, arguably, is a statute which they obtain their power from, which is arguably not fit for purpose in today's world. Now, Mr. Parker's conclusion and the timid approach exhibited in Connaught was unfortunately something of a theme for the FCA in 2020, and brings us to our final event of the first half of this talk, which is London Capital Finance. Now, the collapse of London Capital Finance, LCF, is pretty recent news, and so I'm not going to go through a potted history of it. It's a tale that has been a favourite of private eye in the city columns over the last 2 years, and the financial press has been it's been a staple diet of the financial press for some time. Now, following the collapse, Dame Elizabeth Gloucester was asked to carry out an investigation and to prepare a report, which ran in the end to some 500 pages. And I'm not in any way going to attempt to summarise that, but it's worth considering extracts of the 3 headline conclusions that she came to. Firstly, that the FCA's approach to its regulatory perimeter was unduly limited. Secondly, the FCA failed to consider LCF's business holistically. And thirdly, the FCA staff who reviewed materials submitted by LCF had not been trained sufficiently to analyse a firm's financial information to detect indicators of fraud or other serious irregularity. And as a cumulative result of these failures, the FCA did not appreciate the true nature of the LCF's business or the risks that it posed to consumers. It looked, but it didn't look effectively, properly and deeply enough. And the second and third of these failures are of particular significance to the investigation, since the FCA authorization provided LCF with a badge of respectability. This played a crucial role in attracting investments in LCF's bonds. Now, to say this sounds like familiar failings is an understatement. Arguably, it was Connaught all over again, but not quite. The one silver lining for those of us interested in how FCA enforcement behaves is that much of the criticism levelled by Dame Elizabeth at the FCA originates in the failures of the financial promotions to refer what were reported breaches of SMA to supervision, let alone enforcement. But sadly, the fact is, even if they had referred it to supervision, it's unlikely that it would have been referred on. As one FCA employee in supervision is quoted as saying in the report, "I don't believe, to the best of my knowledge, that there is much training around how to identify financial crime," something which, when you're dealing with a regulator looking potentially at criminal conduct, is not necessarily good news. Now, this is a lot about how the FCA saw itself at the time and continues to see itself, a regulator and supervisor first and foremost, and enforcement and intervention as a necessary distant second. But is this approach changing? Well, this is what Tim will now take us through.
Thanks, Rebecca. And thank you all for attending. I do appreciate it's your lunch hour, my lunch hour, although quite where these days go, one doesn't know right now. If I can have the first slide, Rebecca, that'd be great. Thank you. In terms of the topics that I'm going to deal with, obviously we've got up there the prosecution of Mr. Vishynyak, which was in actual fact originates from 2019, a decision anyway, at least, to summons Mr. Vishynyak to court in relation to breach of 177 FSMA. I don't want to get into all the sort of the weeds with the black letter law, but just in a quick summary, for those that don't know, is the Financial Conduct Authority has various powers, investigatory powers, that derive from FSMA, and in particular section 168. And in 168 it sets out a series of offences that the FCA is uniquely qualified to investigate, and attaches powers that it can exercise under FSMA in order to investigate those offences. I mean, those offences are breach of prohibition, misleading investors, and misleading the market, breach of MLR 2017, and insider dealing. Those are the ones that are mentioned in section 168. And so in relation to the 168 offences, the FCA has the power under various sections that follow, sections 171 through to 176, to compel information, apply for search warrants, compel people to interview. Of course, the FCA can, as a private prosecutor, investigate for other criminal offences, but it can't do so and use those information gathering powers. Now, Mr. Vishynyak, who in fact was acquitted last year, was the subject of an insider dealing investigation, and he was required by the FCA, using their 173 compulsion power, to hand over his phone. And this part of the event is not disputed at all. It was the subject of court proceedings. Mr. Vishynyak accepted that when asked to hand over his phone, he deleted the WhatsApp app that was on his phone, which the FCA were interested in knowing what was on it because they were investigating him for insider dealing. So the interesting aspect of what happened to Mr. Vishynyak is, it appears, at least from my research and having spent time in the organisation until about 2 years ago, that there hadn't been appetite nor actual fact a summons stroke prosecution of an individual for failing to provide information, having been compelled under section 173. And with Vishynyak, that changed. The FCA summonsed him on the 177 offence, and he went to court, and there was a trial last year. This is in the press as well, so I'm not repeating anything that's secret. His explanation for deleting the app from his phone was that he was in fact having a conversation with Alexander Lugovoy, who is a fugitive of British justice, having been alleged to have been involved in poisoning people in the UK using Novichok or various other substances. Now, clearly, Mr. Vishynyak was acquitted. The jury accepted his explanation, and arguably for the FCA, it could look as if they have egg on their face. But the reality is they were faced with little choice. If they were going to get aggressive, this was the action to take. And this is a good example, in my view, and in Rebecca's view, of the more aggressive approach that has slowly seeped into FCA enforcement activity since Mark Stewart took over. The FCA has traditionally favoured regulatory outcomes when looking at misconduct, partly because, or in the main really, because it sets the rules and it has a tribunal which sits internally. I'm not quite sure I can call the RDC a tribunal, but the Regulatory Decisions Committee effectively rubber stamps decisions that the FCA make about sanctioning people for breaches of regulatory behaviour. In this instance, the FCA took a punt. They went to court knowing that there was a prospect of a jury finding in Mr. Vishynyak's favour, which they did. But it seems to me this is an important example of that new approach to enforcement. I'm not suggesting for a minute that we're going to see 177 prosecutions commonplace, but I think it's a good example of the FCA laying down a marker. Going back to what Rebecca was saying a little bit earlier, there is certainly a need for FSMA to be amended and possibly even completely redrafted, because you could argue that those powers, those compulsion powers, need to be beefed up and don't necessarily reflect the technological world that we live in. And you could also argue, actually, in these circumstances, well, if Mr. Vishynyak had been arrested and the phone seized either by police conducting the arrest or the use of a search warrant, then this would have never happened. And that is perhaps, you know, one legacy of the conservatism that sits in there, that the FCA has still in its mind this idea that in conducting some investigations, it can use those compulsion powers and expect that people who it suspects of committing criminal offences will hand over things that might incriminate them. I suspect we will gradually move away from the use of compelled powers completely within criminal investigations over the next few years in relation to the FCA. So may I have the next slide, Rebecca? Excellent. MLR 2017, which is a little bit of a mouthful, but there have been some important developments in the past year. Nothing that actually, no headlines, no Commerzbank type cases, and it seems a bit odd to bring it up because the foundation of actually having this as a topic is the fact that in the last year, various law firms very kindly, I won't name them, but they know who they are, made freedom of information requests to the FCA about how many ongoing MLR investigations there were. And what was discovered was that at least half of them had been dropped in the past year. Now, is that a black mark against the FCA? Obviously, we put it in the second half of this talk, so the answer clearly from our perspective is no. We know that from the stats that not just those law firms, but previous law firms of previous years, and again, they know who they are, have unearthed that when Mark Stewart took over, there was a huge increase in investigations. It's not entirely clear why that happened, these enforcement investigations. There's an argument for saying that activity was undertaken to act as a deterrent. There's an argument for also saying that perhaps it was widening the net in the hope of being successful with a smaller number of investigations. But clearly, the desire to have more open investigations actually clashes with something that's quite ingrained in FCA culture in many ways, and that is the difficulty of ending investigations. It's not always the case that individuals determine that. I mean, if any of those listeners out there are aware of the key data investigation, which has been going on for, or at least the proceedings surrounding it as well, have been going on for over a decade now, and also those of you who may be aware of the HBOS investigation, which I worked on in 2015. In fact, the end of 2015 through to part of 2017. It's still going on now. But what I was getting at is that there is this difficulty of shutting these investigations down. They do drag on. And the point about the MLR statistics is to show that FCA got more aggressive and in recent times with the amount of investigations it opened. It opened up a new front in relation to MLR because there was a strategic decision taken to look at those new regulations and decide that where they were looking at bank conduct and it fell within the 2017 regulations, along with the dual track regime that came in, so that all enforcement investigations are being opened on both a regulatory and a criminal basis. The MLR suite of tools would be added to that. So investigations now being opened under dual track with the MLR 2017 element. But what you have actually is exercising that full suite of powers, but actually being more decisive about dropping cases. Now, I haven't dug into the figures in any great detail, and I suspect there isn't detail that would yield much that I could comment on. But I think the point is that, you know, that the development is relatively recent, that these investigations are being opened, but they're also being closed far more quickly than ever before. And it may be, of course, that those investigations are ongoing in relation to the regulatory aspect. But it strikes me that is a good example of the FCA winnowing down and learning a little bit. They obviously spread the net very wide and opened all these investigations, but have made very quick decisions relative to the FCA's, in the FCA's mind, to shut things down. And that's promising. It's good for the public, for a start, and for consumers, but also for the banks themselves, because it's resources being put in the right areas. And on that point, it just means that the FCA hopefully will be concentrating on the more egregious conduct, which kind of brings us back somewhat to what Rebecca was saying about Commerzbank. I've no doubt that had Commerzbank been transferred for their conduct been transported through 5 years or whatever to more recent times and fallen under 2017, I can't not believe that it wouldn't have been a dual track investigation where MLR 2017 investigation was part of that. So this is a very good example of the change, a wide net cast, but actually an aggressive approach to ending parts of investigations where the evidence just isn't in there. And I say that as an ex-FCA employee. I'm not sort of trying to butter anyone up. I think, but it is unique to the experience that I've had dealing with the FCA, both as a defender and as against them, and also as an employee and a contractor over the last almost 10 years. So that is a positive aspect and definitely a break away from the old regime. May I have the next slide, Rebecca, please? Thank you. This is a very interesting area, which really arises out of something so small, which was the existence of a press notice on the FCA's website in November, which I think most of us missed at the time, which is slightly unfortunate in my terms, because, and I'm not going to talk about anything about it because obviously I'm precluded, but I did actually advise for a period of time on this investigation when I was at the FCA. But I don't know, my involvement with this investigation ceased almost 2 years ago. But the important thing about it is it's a joint investigation with CoLP. But most importantly, is the fact that this individual, Mr. Faithful, was charged with one offence and a money laundering offence, not a FSMA offence. Now, we'll have to see how that plays out. Often any publicity about this particular prosecution will take quite a long time to come into the media. It's unlikely, in actual fact, that there will be anything arising following that court appearance that will take place in January. It may be that we don't hear about this matter for months, even if not years. In fact, given the current COVID crisis and the delays in the court system, if this particular individual, if this matter is a contested matter, it's likely a trial is not going to take place until next year at the earliest. But the important issue here is the non-FSMA offence. Now, bearing in mind, we've talked in passing perhaps about the fact that the FCA is a creature of statute, and I've mentioned to you already about the statutory investigative powers that it has arising from FSMA, the 171 through 176 investigatory powers that it can use to investigate offences under 168. It's very unusual and in fact, I think this is the only time an individual, even in a joint investigation in which the FCA has been involved, where the individual has not been charged with a FSMA offence. Now, I'd love to get into the mind of my ex-colleagues as to quite why this has happened now. I think it's a tremendous development in terms of financial services enforcement, because it is a demonstration of the FCA thinking outside the box and thinking actually holistically. It's a sort of almost an answer, although in slightly different context, to the criticism labelled by Raj Parker and also Dame Elizabeth Gloucester. And the reason I say that is because as those of you on this listening to this webinar, I'm sure there are many out there who have in their time come across clients or those operating in either the unregulated sector or close to it, the types of people that might fall within the purview of the unauthorized business division in enforcement. So that's people conducting activity that might actually be regulated. There might be some question about it, or who definitely are conducting regulated activity without authorization. You see, most of those individuals that fall within the FCA's gaze are actually committing other offences on a grand scale, or alleged to be committing other offences. But the important thing is that that's the actual gravamen of what they're doing. It might be a boiler room fraud where they're conning investors out of sums of money in relation to a product that they're claiming is regulated, or there's some connection to that. So the gravamen of that is not really the FSMA aspect. But the FCA's approach and the FSA's approach has always been that it wouldn't prosecute a case without a FSMA offence on the indictment, which, given that most of the FSMA offences for breach, if we're talking about breach of Section 19 or Section 20 or Section 21, are all 2-year maximums. These are complicated investigations that conduct. They take a lot of time and a lot of person hours by enforcement teams, and can last a very long period of time. And if the cynical part of me says that actually you get to the end of that and the individual is charged and then convicted in a trial situation, and only has a potential of a 2-year maximum sentence, it seems perhaps not the most appropriate outcome in the circumstances. I have to say, I'm speculating quite why this has happened in this particular instance, although I do have my ideas about it. But I think the important thing is the FCA is recognising that its remit is not just purely around FSMA here. It's thinking to itself, well, we got into this probably because of FSMA, but actually, and I've no doubt that the conduct relates to partial FSMA activity, but clearly the gravamen here that they're alleging, it relates to the laundering of funds. So now, again, I don't think, rather like with Section 177 prosecutions, I don't think we're going to see massive amounts of this in the future. But I think the fact that they've done it the first time, they may have done it with CoLP, and there might be an intellectual justification by saying, well, it's not actually our investigation, we're sharing it with someone, so we've had to take that account. I can see that as an intellectual justification. But I can also see that it actually, in my experience of and privilege of advising on UBD investigations in my time there, it better reflects in actual fact what the sort of individuals that fall into the gaze of the FCA are up to, that the likes of perhaps fraud counts on indictments and money laundering offences, of course with FSMA offences if necessary, but could appear and should appear more often when individuals are either requisitioned or charged in joint investigations. So my feeling is this is a very positive development, very unheralded, and interesting from the perspective, it was a good thing for them to get this out into the media, because it turned out actually at the end that it was the only individual who has been charged in relation to an FCA case in the last year. Now, obviously there are lots of reasons for that, which I can only hazard a guess on. The fact that there's a global pandemic on might have been one reason. But in my view, a very positive development. I think in the UBD space going forward, there will be more examples of this. We're not going to see a flood of cases, but there will be a number of them. Finally, and slightly more prosaically, I'm going to talk about the guidance issued on the cannabis sector. So Rebecca, may I just have that? Thank you very much. This is very, very straightforward. And this is actually a good example, though, of FCA kind of sort of positive thinking in the sense of, and probably a good lesson, perhaps learned from the experience with crypto. Medicinal cannabis has the sector for licensed medicinal cannabis and CBD products has obviously completely changed in the last 2 years. Relaxation of licenses that are issued by the Home Office. And luckily, the FCA have had at least the foresight to think about the context of that market growing enormously in the UK, which I think all of us who see what has happened in America, certainly recently in recent elections, various states added even recreational cannabis to non-banned substances. So it's gradually getting more legal on state level in America. And of course, as where Americans are concerned, it takes its lead from California. We tend to take our lead from America. It seems to me that in the next few years, the cannabis and CBD sector will grow, and of course there will be companies that will want to list where they're supplying medicinal cannabis legally. Of course, they're perfectly entitled to list. The interesting thing is that the FCA pointing out to the sort of recreational cannabis companies that exist outside the UK and lawfully in places like California, if they want to invest in medicinal cannabis companies in the UK, will still have the problem of POCA, because recreational cannabis is not legal in the UK as yet. And so what it's doing is it's saying, look, we recognise this is a burgeoning sector where it's legal, there's no problem with POCA. But where there are outside investors who want to invest in listed companies in future, how they operate has to be effectively lawful by UK law. So actually, this is something to praise the FCA about going forward, because they're recognising not a risk, but something that could appear on the horizon and could give wealthy investors in some of these companies in the States a nasty headache if they don't take this guidance. So I think it's a positive note to end my part of the talk on, and just to kind of sum up where we've been. It's a whistle-stop tour around events. I've no doubt there are events we missed, and there are others I'm sure listening to this call who are going to no doubt have more knowledge of than us about this subject. But these events jumped up at us, and we thought they were noteworthy to speak about. There is this inherent conservatism that exists within the FCA, and it arose really still arises from FCA activity, because so many of the senior positions within FCA are occupied by people who worked at the FSA, and the FCA is still, as an enforcement body, still a young entity, and it's still finding its way. Mark Stewart has been in post for 5 years. It'll be 5 years, I think, in October. He is more aggressive, and that's a positive thing. Whether the FCA is ever going to get as aggressive as the DOJ is very unlikely. There would have to be, in my view, a significant change to the structure of how regulatory decisions are made. Effectively, you'd have to abandon the RDC as a concept and put it outside the FCA in order to create a situation where the FCA had the confidence and not the fallback of going to the RDC when it wanted to regulate conduct. And that would probably then encourage it to take more criminal cases and perhaps put the resource into that area. But there are positive shoots. That's why I said it's strange to say about MLR 2017 investigations being cut that's a good thing, but it is, because the resources from the investigations that have been dropped can then be diverted to other areas of misconduct as far as the FCA is concerned, which actually is good for the public. As I said, it's good for banks that are under investigation, or even individuals. And it's actually, for those in the defence community, it should generate more proper work in the future. Thank you.
Stop sharing, and then I can. There we go. I can see there's one question down the bottom. Let's see what that says. Can you see that as well, Tim?
Yeah.
It's from Guy Wilkes back in 2011.
Oh, there you go.
The FSA
being corrected by Guy. Yes.
Well, there you go. You fill your boots for that one, Tim.
Well, I can't. Guy's absolutely right. I'd forgotten about that. My memory, he's got a longer memory than I have, and he was there a lot longer. Now, Guy is now successfully ensconced in Michigan de Rea. I think my point was that, and he's right about that, but is that in my experience, certainly in the time I spent there and since, that there hadn't been a prosecution involving a non-FSMA offence, and there didn't seem to be any appetite to do so. And I think particularly in the UBD space, which Guy knows very well about, it does seem to me that it's concentrating only on FSMA, or even having FSMA on the indictment and also other offences doesn't always accurately reflect the conduct that is complained about. But he's right. always good to be corrected. But I suppose the other aspect of that is, from Guy's perspective, that was 10 years ago. So even if there was appetite 10 years ago, it's taken until this past year for the appetite to re-emerge.
I think that, looking at it, is all the questions. Unless anybody has got anything else that they would like to ask, or like we said at the beginning, I think our email addresses are both on our websites, and feel free to email if there anything else that you would like to ask or discuss. But unless there are any more questions, thank you very much for joining us, and I hope we kept your sandwiches and soup company sufficiently. Thank you.
There's another question.
Another question.
Yeah. Excellent question. Should the FCA be encouraged to prosecute rather than regulate? Yes. That's my view. The cynic would say, in me, looking at the number of cases that the FCA has prosecuted, admittedly, it's a small organisation, but it doesn't lose many cases. In fact, I can't think of a time. Vishynyak is very unusual because it's non-compliance with the regulation. You could argue on the facts it possibly could have been a perverting type prosecution. But that's a very unusual one. If you take that out of the mix, I'm not sure the FCA has lost a case against individuals since Tabanula, and Tabanula itself sticks out. Again, I'm sure Guy will correct me, someone else will correct me. But the reality is, there's an argument saying, and Rebecca knows more about this in the sense that she's acted in so many of these complicated trials, is that you have to you're going to lose some of them on a percentage wise in front of a jury. You just are. The SFO knows that very well. But you have to take them, otherwise what's the point?
Well, you don't take them, do you, Tim, is the reality.
Yes.
You have to be shown to be prepared to do it if you have to. And
yes.
And as long as the code test is passed,
yes.
it's time to proceed and get on and prosecute these people.
Exactly.
Otherwise, you have to ask yourself, what at the end of the day, what becomes the point?
Exactly. And I think the question relates back, I think, quite well to the point I made earlier about RDC. I have pretty militant views about the existence of RDC, not because it's the concept behind it's wrong, but it does provide this safety net and a regulatory outcome. Obviously, in certain instances, it's never going to be the appropriate outcome if the code test, etc., is met, because you're going to prosecute. But you do wonder whether investigations would start out on a very different basis, knowing that actually, well, if we do want to regulate the outcome, we have to go externally to a properly independent tribunal, whether that would change the appetite. So my view is, yes, and I'm not just saying that now because I'm in the defence community and would like some more work. I just think that the market would work. There's an element of deterrence in there as well, because believe it or not, I don't believe that individuals or companies take much notice of regulatory outcomes. I'm sorry to say that. It sounds like a horrible thing to say. It hurts them in their pockets. They pay the fine and then they move on. What actually hurts people is if you take away their liberty or their property, their personal property.
Yes, agreed. I note the hour is up. Unless there are any other questions. I think
can I get Rebecca? I just had some more thoughts on what Guy was saying, with the risk of digging myself a bigger hole.
Now,
reading his question, reminding myself, it's interesting because the guy's question says back in 2011. Well, it's not a question. He's correcting me factually, which is absolutely right. He says back in 2011, the FCA took action against Thomas Wilmot for boiler and fraud, no FSMA offence. And then he says they used CPS to prosecute the FSA investigation, but had R. Rollins come out earlier, the Rollins case come out earlier, the FSA would have prosecuted it itself. I guess in my defence, what I would say is the fact that it was CPS prosecuting it and not the FSA is probably the key aspect there. Guy may disagree with me, but my view is, having been in CPT, I don't think, certainly from my time there, that there was any appetite to have prosecuted solely for a non-FSMA offence. That's what I could say. So I think this is a sea change, but I think that's also the reason why that's come about is there always was a chief criminal counsel within FSA, which there is in FCA, but the FCA team, criminal prosecutions team, is now stacked with very experienced criminal lawyers who are who know what they're doing. So I think the fact that we've got this potential prosecution of Mr. Faithful is significant enough, and so I think that is consistent with what I'm saying.
Well, it's a different landscape as well at the time, wasn't it? And it may
absolutely
get the CPS involved. They wouldn't have taken it on had it not been charged and prosecuted in the way it was.
Yeah. Right.
Unless anything else from you, Tim, I suggest we let these good people get back to their day jobs, I think.
Yeah, absolutely. Thank you all very much for listening in on my witterings, but more importantly, Rebecca's actually lucid commentary on events. It's been our pleasure. Like we both said, if there are any questions that arise that you think of later on, please do get in touch. Always happy to have a chat over email or even a call or whatever it is you would like. But we've really
what happened there?
Nothing, don't worry, someone sent me a message, but anyway, we've had a lovely time, and we hopefully will do it again sometime.
Thank you, everybody. Enjoy the rest of your day.